Justin, Leo Dow is the withdrawal.
Yeah, it's gonna be withdrawal. I think PMO 3. No drugs.
Okay.
I think that's it. She got detained by a drug court.
You got it. Okay.
Gloria, can you hear me?
Yeah.
Oh, hey.
Hi.
I obviously had no idea Porfido was coming into this
No.
until this.
Yeah, no, I don't think anybody did.
Is there like a procedure for me to get the discovery to him, or do you guys do that, or how do you want me to do that?
So I think he will be calling you to get the discovery because he's going to be mailing you guys a substitution of attorney.
Okay.
So once somebody from your office, I don't know if they're going to want Sue will have you do it, or if he's going to was like already assigned a public defender.
Right.
They would have to sign the substitution of attorney, file it on e-courts, and then essentially whoever is going to be assigned, either you or that person who signs it, would be responsible. But I did email him this morning all of the exhibits that I intended on using. And he said he was fine moving forward without viewing any of the videos. So,
all right.
Yeah. So we'll see what happens.
Right. Thank you.
Yeah.
But yes, it can be done.
All right. It's the jail ready with the defendants?
We're all set.
All right, great.
And what's the link for the jail that we could use?
I'll show you.
Okay.
Okay. That part is easy. I thought it was going to be like 5 minutes.
No, it's the same thing as what.
So they had a drop down menu, so they didn't have it.
I'm guessing after each phone call.
But I don't know how, see, you are not gonna be able to do that at home, because you won't be going to your outlet. She will be. Yeah, so she can do it from on her personal laptop. Yeah, because if she signs in as herself on the.
As long as I have all. I should going through.
I mean,
I just
they're
have to know
safe.
how to
Yeah,
sign
so
it.
you should be, you didn't try that at home yet?
Or I don't have the RC open, I have nothing.
All right, then I'll let you guys do. Okay, thank you.
That's why. From home would be different. Gotcha. That's pretty cool.
This is Judge Hanna. Is, let's see, our defense. Good morning. Is there a sheriff's officer from the jail?
Yes, Your Honor.
All right, you can hear me?
I can.
All right. We have, let's see, it looks like 3 attorneys on the screen. Can all of the attorneys hear both me and the jail?
Yes.
Ms. Calzone
Yes, good morning, Your Honor. Yes.
and Ms. Rispoli
Good morning, Your Honor. Yes.
and Mr. Talone?
Yes, Judge.
All right, very good. We'll conduct then the first appearances for the defendants. I see 4 defendants, although we have 6 on the list. I'm just going to call out the names. Rijah Scott,
He's here.
Daniel Steffner. All right, Mr. Steffner is there. Nasir Joseph. All right, Mr. Joseph is present. Elijah Walker is also present. Leah Dahl is present. Okay. And Antonio Lopez. All right. All 6 are present. All right. I'm going to ask, we're going to conduct the first appearance. That's to make sure that all of you are aware of your rights and the charges against you and the consequences if you're found guilty. And I'm going to place you all under oath or affirmation, and I'm going to ask you to answer some questions to make sure you understand the charges and the rights. So everyone, please raise your, all defendants, please raise your right hand. Do you swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth? Answer out loud. All right, all defendants have answered affirmatively. You can lower your hands. Are any of you currently taking any medication or under the influence of any substance, alcohol, drugs, or anything else that might affect your judgment or your ability to understand today's proceedings? If so, raise your hand. All right, no one is. All right, do any of you have any physical or mental condition that might affect your judgment or your ability to understand today's proceedings? If so, raise your hand. All right, no one has raised their hand. Do all of you, are you able to understand English? All right, does anyone need the assistance of an interpreter? All right, no one does? All right, we'll go through the, we'll go through the charges when it's your turn. But if you are found guilty, either by a jury after a trial, or you plead guilty, you will potentially be subject to a sentence of jail and substantial fines. Does everyone understand that? You have the right to remain silent. If you decide to speak and give up that right, anything you say may be used against you in court. Do you understand that? Okay. You have the right to be represented by an attorney, and I believe one of you has a private attorney, Mr. Porfido. That's you, Mr. Lopez, correct? Yes, and then for the others, you will be represented by Ms. Calzone of the Public Defender's Office. For those of you who are represented by the Public Defender's Office, you do have the right to hire your own attorney if you're able to do so, and that attorney should file a notice of appearance promptly. Does everyone understand that? You have the right to have your case presented to the grand jury and considered for indictment. If you are indicted, you have the right to a jury trial. You may give up both of those rights, the right to have the case presented to the grand jury and the right to a jury trial, if you knowingly, voluntarily, and intelligently waive those rights. And one of the ways to do that is by pleading guilty. However, you are cautioned not to waive any of your rights until you have spoken with your attorney. Does everyone understand that? Right, everyone does. If you are not an American, is anyone not an American citizen? Raise your hand. All right, everyone is an American citizen. If you're not an American citizen, there can be immigration consequences, deportation, and not being able to re-enter the country if you are convicted. We do have a pretrial intervention program. It's usually called PTI. A defendant who is charged for the first time with an indictable offense may be eligible to apply for admission to PTI. There are rules about who qualifies and who does not, and you can discuss that with your attorney. The PTI program is designed so that if you successfully complete it, the criminal charges against you are dismissed. There is an application fee of $75. However, it will be waived for anyone who is represented by the Public Defender's Office. And again, you can speak with your attorney about that. Does everyone understand that? All right. Have any of you served in the United States military? All right, no one has. We do have a drug court program. The mission of the drug court is to stop substance abuse and related criminal activity through intensive supervision and qualified substance abuse treatment and counseling. Applications for the drug court program are available, and you can discuss that with your attorney. Does everyone understand that? All right, thank you. Is there anything else from counsel on the first appearance?
No, Judge.
No, Your Honor.
All right, let's. I understand that there is an agreement with respect to Ms. Dahl. Is that correct?
That's correct, Judge.
All right. I'd ask Ms. Dahl to go near the phone, please. All right. The case number for Ms. Dahl, the promise gavel number is 20391, and the complaint warrant number is 2020-99-1417. Counsel, would you enter your appearances, please?
Good morning, Judge. Justin Tillman on behalf of the state.
Good morning, Your Honor. Brittany Calzone on behalf of Ms. Dahl, hearing via video court.
All right. And I should add that today is Wednesday, March 18th. The first appearances and the detention hearings are being conducted remotely. No one is in my courtroom. All defendants, including Ms. Dahl, are at the county jail, and all attorneys are appearing remotely as well via separate video links. All right, I'll ask then, Mr. Tillone, for you to state the terms of the agreement.
Thank you, Judge. Judges, I've been made aware that this defendant has a VOP hold. I believe it's for drug court, if I'm not mistaken. With that, Judge, we would ask that she be released on these charges on PML level 3, refrain from excessive drug or alcohol, and abide by probation's recommendations.
All right, and when is the VOP scheduled, do you know?
Judge, I know that they did hear, and they do have a hold on her still. I don't know when the actual hearing is, though.
All right, on the list that I have, the next appearance for Ms. Dahl is April 13th, but that's a pre-indictment conference before Judge Taylor. All right, Ms. Calzone, is that the agreement that you reached?
Yes, Your Honor, that's my understanding.
All right, would you explain to Ms. Dahl, and I want to make sure she can hear this, but would you explain to her exactly what she has to do when she's eventually released to comply with pretrial monitoring level 3?
Certainly, Your Honor. Ms. Dahl, I do apologize that you and I haven't actually met or spoken before, unfortunately, because of the circumstance. Just access to the jail has been restricted. So I just wanted to start by apologizing for that. If and when you are released, I know you have this hold, you need to report to pretrial services in person by 3 p.m. the following business day. I would advise calling in advance at the moment, considering, again, the circumstances are not as they usually are. However, you will have to report to them weekly, but it will alternate between being in person and over the phone. That may, again, change. They may have you reporting only over the phone to avoid contact. However, again, that's all within their discretion. So it's important that if you are released, give them a call, arrange a time to meet with them if that's what they want, and then you will have to report weekly to them.
Ms. Dahl, do you understand that?
I do, but I don't know where that is.
Okay, so you've been to the Morris County Courthouse, right?
Yes, but I live in Essex County, so I
Okay.
still have to report in Morris County.
That's correct. Yes, that's correct. Again, I would give them a call before you head all the way over to Morris County, because they may not want you coming in at all. But it is important to contact them and just follow whatever instructions they give you on your reporting requirements.
We have Tony Montanez here from pretrial, so if you just pay attention.
Hi, how are you? So under the circumstances, we can have the intake done at the Morris County Superior Court by phone, and then we could transfer the case to Essex so she can report there. So she doesn't have to come here tomorrow.
Perfect. Thank you.
But we'll give you that phone number. It's going to be on your order.
All right, do you understand that, Ms. Dahl?
Yes.
All right, and the other conditions of your release, besides just the PML level 3 requirements, are no use of non-prescription drugs and no excessive use of alcohol. Do you understand that?
Yes.
All right, is there anything else? Was there anything else, Mr. Talone?
No, Judge, thank you.
Anything else, Ms. Calzone?
No, Your Honor. Thank you.
Okay, thank you, Ms. Dahl.
Your Honor, could I ask a favor?
Sure.
Is it possible we could do Antonio Lopez and Rajay Scott one after the other for classification purposes?
I'll send an email to you.
Yeah, for Mr. Lopez, we'll have to get Mr. Porfido on the line, but if we can do that, sure.
Okay, thank you very much.
Judge, we could do Mr. Scott then.
Okay. Do the conditions go in here? Or they're in there, okay. All right, I'm sorry, so let me just sign this then. And do you see a VOP date for Ms. Dahl? A VOP hearing date? No?
I can check.
Check that, all right. Well, I'm going to have, just for Mr. Talone and Ms. Calzone, I'm going to have Madam Clerk check and see if there's a VOP date for Ms. Dahl, all right?
Thank you, Judge.
All right. All right, the matter now before the court is State of New Jersey against Rajay Scott. The promise gavel number is 2362, and the complaint warrant number is 2020-701424. We've conducted the first appearance earlier today, and we'll begin with the appearances of counsel.
Good morning, Judge. Justin Tone, we have the state.
Good morning, Your Honor. Brittany Calzone on behalf of Mr. Scott, appearing via video.
All right, Mr. Scott, can you hear everyone?
Yes, I can hear you.
Okay, thank you. Actually, Mr. Talone, would you just review the charges, please?
Yes, thank you, Judge. Judge, this defendant is charged with a second-degree false public alarm. And actually, Judge, I just wanted to make a quick amendment to that. The false public alarm was charged under 2C33B. It's supposed to be actually under 2C33A1B, which is the subsection dealing with a deadly weapon. The language in the actual complaint does reference the deadly weapon, which is, so that would be accurate. I think it was just more of a Scribner's error. They put the wrong subsection B. So I would like to amend that currently on the record. Otherwise, Judge, he is charged with a third-degree terroristic threat and a disorderly persons PDP, Judge, on a separate summons.
Okay. And the top-level charge is a second-degree charge?
That is correct, Judge.
All right, Mr. Scott, there is a presumption of incarceration for someone who is convicted of a second-degree charge, and the maximum jail time for that is 10 years in jail. Do you understand that?
Yes, sir.
And there are very substantial monetary fines for second-degree charges as well. Do you understand that? $150,000 is the maximum monetary fine for a second degree. Do you understand that?
Yes.
All right. And do you have any questions about the rights that we went over during the first appearance?
No, I do not. No, I don't.
Okay. All right. Let's proceed then. The state has moved to detain, correct?
That's correct, Judge.
All right. And have you provided Ms. Calzone with the discovery that's necessary for a detention hearing?
That's correct, Judge.
Ms. Calzone, did you receive?
I have,
Did you receive that?
I acknowledge receipt.
Okay. All right. Again, Mr. Scott, your attorney, Ms. Calzone, has acknowledged receiving the discovery for the detention hearing. If there is a finding of probable cause by the court, we will move on then to the detention hearing. In your case, because of the nature of the charges, there is a rebuttable presumption against you being detained, and the state must prove by clear and convincing evidence that no amount of bail and/or non-monetary conditions of release will reasonably ensure three things. One is that you will appear in court when required. The second is the protection of the safety of any person or the community generally. And the third is that you will not obstruct the criminal justice process. Do you understand that's the purpose of a detention hearing? Okay.
Yes.
All right. You do have the right to testify at the detention hearing, present witnesses, cross-examine any witnesses that may testify against you, and you may also present evidence by way of what's called attorney proffer. In other words, Ms. Calzone will simply tell me what you would testify to. Do you understand that?
Yes.
The general rule is that if you do testify in a detention hearing, the testimony is not admissible against you in court in any other judicial proceeding. However, there are 5 exceptions to that general rule where the testimony that you give would be admissible against you. Do you understand that?
Yes.
And what we'll do is we're going to proceed first by attorney proffer. Actually, Ms. Calzone, did you have the opportunity to speak to Mr. Scott?
I did, Your Honor. This detention hearing was actually supposed to be heard last week, so I did have an opportunity to speak with him before that. We have not spoken in a while, and therefore I've already spoken with AP Talone. I don't know how Mr. Scott feels about stipulating to probable cause. So that's just one issue that I can speak with him about in front of Your Honor, if that's okay.
All right, but have you spoken with Mr. Scott about proceeding via attorney proffer and the?
Oh, yes, Your Honor, yes. We've
All
spoken
right,
about
and is that what he wants to do?
That's correct, Judge.
So far. Okay, and then, Mr. Scott, what I'll do is we will proceed by attorney proffer. In other words, Ms. Calzone will tell me the facts that you want me to hear, and then I'll ask you at the end if you do want to testify. Okay?
Yes.
And if you do want to testify, then I'll explain to you the 5 exceptions where your testimony could be used against you to make sure you're making a knowing, intelligent, and voluntary decision to testify. Do you understand?
Yes.
All right. If you are detained prior to trial, the state must secure an indictment against you no later than 90 days from the date you were first lodged in the jail, and then bring the matter to trial no later than 180 days from the indictment, although that 180-day period can be extended for various reasons. Do you understand that?
Yes.
All right. All right. Well, we need to proceed on probable cause. Ms. Calzone, do you want to ask Mr. Scott about that?
Certainly, Your Honor. Raja, you and I had met before appearing today, correct?
Yes.
Do you remember me, and please, if the answer is no, please say so. Do you remember us talking about stipulating to probable cause? If you're hesitant at all, please just say so.
I don't remember.
Okay, yeah, I know that conversation was a while ago, so Your Honor, we are going to respectfully hold the state to its proofs on that issue.
All right. All right. I will hear then from Mr. Talone.
Thank you, Judge. Judge, I submitted online several items for discovery. I believe you should be in receipt of those. One of the items I did take out, just for Your Honor's notice, is a CCH. I took that out, so I'll proffer to anything on there. As for probable cause, I will rely upon the complaint affidavit and clear, which is S1, and S4, which is a Morristown investigation report. There are, I guess, 4 total exhibits: S1, S2, S4, and S5.
I do not have. I don't have S4. I don't have the police report. I do have the CCH, and I have the affidavit of probable cause. Obviously, that's in the complaint warrant.
Judge,
So
I did send.
Can we print that out?
Yeah, I printed everything.
For Scott?
For Scott, yeah.
Yeah, I printed everything.
And Judge, I sent over for Steffner as well.
Steffner, I received.
I'll send it to you, Camila, so you can find it.
All right, well, why don't we proceed then? I certainly have the affidavit of probable cause from the
Yes,
warrant.
Judge. I think that probably has enough in it as well. Otherwise, I could proffer the rest until Your Honor gets that exhibit. Judge, this is an incident that occurred on March 3rd in Morristown, approximately 1:23 in the morning. It was actually at a bar called the Grasshopper off the Green. Bar security was there on the 2nd floor and noticed that the defendant was acting in an aggressive and angry manner. Defendant was heard by security saying that he needed to leave the bar. I mean, the defendant was saying this to the security person, that he had to leave the bar or he was going to shoot someone. A patron of the bar stated that he was in the bathroom. The defendant came in and saying that he had a .45, which is a type of handgun, Judge, and demanded that patron's drink. At that point, 2 more patrons walked in and the original person was able to walk out. When police arrived, defendant was up against a wall. He was apparently on crutches. Defendants approached the defendant. He became verbally abusive and put his hand in his pocket and refused all commands to show his hands. When police went to arrest him, he resisted them by placing handcuffs, when they were trying to place handcuffs on him. Police were able to detain him, Judge. There was no weapon found. However, defendant then made statements that he was a gang member and challenged anyone and everyone to a fight. That includes all of the officers, Judge. Once at the police headquarters, defendant continued to challenge all the officers to fight and threatened to kill their families and to kill their children if he saw them on the street. Defendant did make statements at that point that he wanted to die and he was brought to Morristown Medical Center, which he was later discharged that night. Judge, I think when you look at the statute for false public alarm, specifically when reporting or warning of reporting with a deadly weapon, which is obviously would be a firearm, Judge, this defendant does fit the statute for false public alarms and the terroristic threats against the officers and their families as well. So the state would submit.
All right, Ms. Calzone.
Thank you, Judge. I'd first like to thank Mr. Talone. We had discussed yesterday the fact that the charges were charged under the wrong subsection. So thank you for correcting that. However, I still think even when charged under the right subsection, that the state has significant issues with the weight of the evidence in this case in being able to prove particularly the second degree offense. They must prove an impending situation of a person with a deadly weapon. However, all that's been provided to the defense so far are hearsay statements from police officers. So we have various reports from various officers who arrived on scene who allegedly spoke with a bouncer and a patron who had heard Mr. Scott allegedly say these things. However, it does not appear that an actual statement was taken from these witnesses. So we, in fact, have nobody who can definitively say what Mr. Scott said. And since he's only being charged with using words in this case, I'm not sure, unless they have more information that has not been provided to date, I'm not sure how the state intends on supporting their burden of proof with regards to the second degree offense. That is the only way they can prove that charge. I'd also point out, Your Honor, with regards to the allegation that Mr. Scott was saying he was a gang member to the police, that is not my reading of the police reports, because we have one from, the only one in which any reference to being a gang member is made in Patrol Officer Adam Hagelin's report. And that, again, was allegedly said to this bar bouncer, not to the police, not to anybody who could actually stand there and give a definitive statement about Mr. Scott's exact words in this case. He does deny ever saying that he had a 45. He's denying these allegations, Judge. And most importantly, there was no weapon found. Not only did they search Mr. Scott himself, but they searched the entire second floor where they said he had made these allegations. There was no weapon recovered at all. And Your Honor, when the police arrived on scene, they had found him right where he allegedly, where he was reported to be. He did not attempt to flee the scene after police had already arrived and had indicated they were looking for him. In fact, when they approached him, they said, are you on crutches? And he said, yeah, and I'm not going anywhere. So I would say that's the opposite of a flight risk there. There are substance abuse issues that may be at play here. He was intoxicated at the time of the arrest, as was acknowledged by the police officers. And Your Honor, in light of those facts, I did actually sit down with Mr. Scott last week and fill out an application for his referral to the Mental Health Association of Essex and Morris County. We did fill that out together, and that was my reason for asking for the adjournment last week to see if we could get him admitted into that program. However, on Monday, I did receive a call from Deanna Ackerman, who's their admissions counselor, and she stated that under the circumstances, they are not taking new applications at this time to their program. However, she indicated that based on the application we had submitted, he is a good candidate for that program. Unfortunately, they cannot confirm his admission right now, but I think that
May I ask, I assume when you saying present circumstances, you're referring to COVID-19?
That's correct, Your Honor. Yes, the fact that the state is shutting down.
Right. Okay. Right. As opposed to Mr. Scott not being a good candidate.
That's correct, Your Honor. I apologize. I should have clarified. Yes, due to the fact that there are significant safety concerns going on right now with the COVID-19, they are not willing to take him on, not because he's not a good candidate, but because they're not taking anybody on at this juncture.
May I ask, does Mr. Scott, and again, you don't have to answer this, but it might be helpful, does he have a treating physician for any of those issues currently?
He does not have a treating physician for a substance abuse issue. That's why he's been referred to this program to see if he can be evaluated for these issues. He does not have a treating physician at this point. This was the first step to try to get him pointed in the right direction to address those issues.
If he is released, is he willing to do anything in particular? AA meetings, NA meetings, anything?
He was very interested in participating in this program. We have filled out a multi-page application. We sat down and did that together. He's very interested in this program. He, along with speaking with his family members, there is a concurrence generally that he does need to seek some treatment. for these substance abuse issues. And he recognizes that. And that is why he agreed with me that an adjournment was appropriate to try to see if he could get pointed in the right direction through the Mental Health Association. Again, unfortunately, there's been no confirmation of him being accepted, not through any fault of his own, but because of COVID-19.
All right. Is there anything else, though, on probable cause? Let me make that finding. Anything else on probable cause?
No, Judge, no.
All right. Okay. Probable cause has been described by the Supreme Court in State versus Sullivan as a well-grounded suspicion that an offense has been committed. The Supreme Court has described the probable cause burden as a low burden and has instructed trial judges to determine probable cause using a common sense practical standard and not to use technical concepts, stressing that probable cause is a flexible and non-technical concept. In determining probable cause, hearsay information is available and can be considered. I do find that the contents of the affidavit of probable cause adequately establish probable cause for each of the charges against Mr. Scott. The fact that, and Ms. Calzone is correct, that there is hearsay obviously in there coming from the patrons and the bouncers or other staff members at the Grasshopper off the green. However, the police were on scene and took those statements and found them to be credible. I would also add that what the patrons and the staff members at the Grasshopper had to say was to some extent corroborated by Mr. Scott's combative conduct towards the officers, combative and threatening conduct towards the officers, and but there's more than enough information establishing probable cause to believe that Mr. Scott committed those crimes. So I do make the finding of probable cause only for the purpose of the detention hearing. All right, let's move on then to the detention hearing.
Thank you, Judge.
Mr.
Judge, just
Salone.
say is asking you to detain this defendant as he's a risk of failure to appear, a danger to the community, and a risk of obstruction as well. Judge, to admit the remaining exhibits, S2 is his PSA, which is a 3-3 PML1 recommendation. And then also admit S5, which is his driver's abstract. Judge, look at the nature and circumstances. We've gone over those circumstances. At this point, the defendant obviously caused a situation where he's making statements to individuals at the bar, not just one person, but at least two people, stating that he had a handgun in his boot and that he would shoot up the place. That is very concerning, Judge, as that does cause that panic or alarm that the statute seeks to eliminate from happening. Looking at his history and characteristics, this defendant was just released off of U.S. probation for felony possession of a weapon. It was a felony, Judge. That was on his CCH, so I will proffer that. He was sentenced to 60 months back in September of 2014, where he initially received 3 years of supervision starting in June of 2015. This stems from a firearms arrest, Judge, back in West Patterson in 2011. Interestingly, Judge, he was also on November 8th of 2017, he was released and was revoked from his probation and sent to prison for six months and had additional 2 years supervision on him for that probation. Again,
so when was the revocation?
Judge, it was November 8th, 2017. He was released and his, I'm sorry, Judge, he was revoked from probation and placed into for 6 months and has served 6 months from that. And then they gave him an additional 2 years of supervision after that. And he actually has several of these, Judge, so I'll go through the rest. He has
Okay.
another in November, a year later, November of 2018, released and revoked for the second time, and he served 36 days and supervised for an additional 12 months. In September of 2019, he was released and revoked for 12 months and served 12 months in prison. And at that point, Judge, it looks like they, at that point, since this has been supervised since 2015, so by September of 2019, he was actually given time served at that point, and probation was officially terminated. And believe it looks like he was released from prison in December of 2019. That's a proffer from the probation officer, Judge. Another proffer from the probation officer is that this defendant is actually a validated gang member with the Grape Street Crips. At this point, defendant is homeless and is known to use PCP and has, from what I've been told, no support system. He used to live with his aunt in Cedar Knolls and as well. In total, Judge, he has those 3 total U.S. probation violations. There's 3 of those. His New Jersey history includes 5 indictable convictions, 6 disorderly persons. Those in New Jersey indictable convictions, latest one was in September of 2019. That coincides with one of his violations, where he received a 365 state prison sentence. In December of 2011, he has a third-degree possession with intent to distribute on school property, received 3 years state prison. And in November of 2011, he also received a 364 for PWI for possession of CDS and fourth-degree trespassing. Turning to his failure to appear, he has 1 in 2007, plus his driver abstract has a failure to appear. More recently, Judge, on February 26, 2019, and October 2017. As for his juvenile adjudications, Judge, he has an old robbery back in 2003, and he has 2 other misdemeanors, obstruction of justice in 2004 and 2005. So, Judge, I think in the totality of the circumstances, this defendant does pose a danger risk community as he's actively spreading and threatening harm that includes causing a shooting in an entire bar and threatening every officer and the families that he came in contact with. Defendant has those confirmed gang affiliations as well. Defendant is a risk of obstruction seen by his inability to conform to the officer's commands. His failure to appear is seen by his more recent failure to appear in the municipal court, the one from 2019. Lastly, it's unlikely this defendant can be supervised on any level of monitoring, as he has had those 3 violations of U.S. probation, and he, which just ended with him having to serve more time, Judge. None of those previous periods of detention, including the first one, which was 6 months, seemed to deter him from continuing to violate or commit more offenses. Judge, this offense did occur within 4 months of his release, and he has low ties to the community and appears to have underlying drug substance abuse issues as well. So, Judge, I think given the circumstances, the state has met its burden to detain this defendant.
All right, thank you. Ms. Calzone?
Thank you, Judge. I'm just going to reiterate all the arguments I made regarding the weight of the evidence in this case. Again, we have no statements from the actual individuals who say they heard Mr. Scott say these things. And that is the only way, in fact, that the state could meet its burden of proof on the second-degree offenses. With regards to the allegations that he is a gang member, Your Honor, those are unrelated to this incident. This is not a violent crime. He's not charged with a violent crime or any gang-related activity here. Again, I would note the substance abuse issues, which Mr. Scott does recognize and does recognize he needs to address. Again, which is why we decided to go the mental health association route. With regards to his risk of flight, I would note, Your Honor, he is sitting on video right now because he does have a broken ankle and he is on crutches. He broke that ankle January 4th. He had to have surgery January 7th. He was supposed to have an appointment on March 11th with his podiatrist, Dr. Skinicki in Morristown. Obviously, he missed that appointment because he has been incarcerated. But I would argue that he's literally not a flight risk because he is not only physically restricted in being unable to travel, However, he's also tied to his necessary medical treatment. He needs these follow-up appointments to make sure that ankle properly heals. He is a lifelong resident of New Jersey. He does still live with his aunt, Loretta Gabriel, who our office has been in contact with. She's a licensed cosmetologist. She's been caring for him since he was a child. Both of his parents are deceased. He is a high school graduate in Warren High School. He did work at ShopRite in Cedar Knolls in the deli department for three years. And most recently, he also worked at Panera. I would note that the PSA recommendation, he's a 3-3 on his risk scores, and the recommendation is PML1. He does not have any pending charges. Most of his convictions, the vast majority of his convictions, are from over 10 years ago here. I would also know that they are all nonviolent, including the federal offense that Mr. Talone has mentioned. That was a possession offense. Similarly to almost everything else we have here, possession, wandering, criminal mischief. Again, 3rd and 4th degree offenses and VP offenses, all nonviolent. And I would note, despite that criminal record, so acknowledging the convictions, he still only has one failure to appear in Superior Court. And that's back from 13 years ago in 2007. Mr. Talone has cited to his driver's abstract, but the failures to appear on a driver's abstract are not included in the public safety assessment for a reason. They are in municipal court, they are lesser offenses, and therefore they should not be given as much weight. So Mr. Scott has not been charged with any violent offenses here or ever. And even if the state's allegations are taken at face value, what we have here is he's being charged with words he allegedly said while intoxicated. And again, that's if we're taking the state's version of events at state value. I submit, Your Honor, that words, which he was literally unable to carry out because he didn't even have the weapon he was allegedly saying that he had, does not make him a danger to society such that it necessitates him being incarcerated, particularly under the circumstances with COVID-19. He is not a flight risk, I submit. I understand the violations of probation. However, he has so many ties on him right now. He's physically tied because of the foot. He is at increased risk, I submit, as an incarcerated individual because of that foot. He does have a healing wound. He had surgery, open wounds on that foot. And I submit he's certainly not going to get the medical treatment he needs if incarcerated. We have no foreseeable end in sight for people who are being ordered incarcerated right now. And I think that's a very real situation that needs to be given heavy weight here today.
Well, let me ask Ms. Calzone, you've raised two issues for Mr. Scott. One is a substance abuse issue, excessive use of alcohol. Mr. Talone raised another one, which was use of PCP. And you've also raised mental health concerns. So what would be done if he were released about any of those issues? I'm not hearing any concrete plan from you.
Your Honor, I cannot provide a concrete plan at this point. The application to Mental Health Association was trying to take the first step to form that concrete plan. There has been no concrete plan in place, and there is certainly not a viable way to set one up right now. I say that not through any fault of Mr. Scott's or quite frankly of my inability to try to set something up for him right now. It's just not feasible at this time to get him into a program right now. They are not taking applications because of COVID-19. However, I think it's
let me ask this. And again, this is probably something that the Mental Health Association can't answer either, since I'm not sure anyone has an answer, but did they discuss when they might resume accepting new patients?
No, Your Honor. And none of us can even say when we're going to be reporting back to work in person. So I don't think that's something we can, I wouldn't ask them to provide a timeline for that right now. But I think that speaks to the very uncertainty that we're all looking at right now, which is that we don't know when Mental Health Association is going to be able to take him, but we also don't know when his next court date is going to be, when he's going to be able to actually address these issues. And I think that keeping him incarcerated in the meantime, when he's never been charged with a violent offense and has not been charged with a violent offense here and does want to seek help when that help becomes available, I do not think that his incarceration through this extended, very uncertain, very, quite frankly, scary period of time right now is warranted. I think that that's far too speculative of, what will happen down the line. And he will literally be a sitting duck in prison with a broken foot for the entirety of the time that we are facing these issues as a country. I don't think that keeping him incarcerated is the right approach here, particularly in light of the fact that he is willing to seek that treatment once it becomes available. I have spoken with his aunt Loretta as well. He is more than welcome back in her home if he's released. He's not going anywhere, Judge. He's got to go to the doctor. He really does need to go to the doctor. He did already miss his appointment. He has a healing surgical scar, surgical.
All right, and that's 208 Justin Court in Cedar Knolls?
I'm sorry?
Is that where, is that the address?
That's correct, Judge. Yes. That is the address where his aunt lives, and that's where he would be staying, 208 Justin Court.
And what's her last name?
Her last name, sorry. Her last name is Gabriel. Her name is Loretta Gabriel. She's a licensed cosmetologist. She has been in constant contact with our office.
Okay, Mr. Scott, is there anything else that you wanted to Ms. Calzone to tell me, or do you want to testify to anything?
Well, I wanted to say something about the February 26th issue that he mentioned. I was already incarcerated in 2019, so I couldn't make it there. I was in Monmouth County at the time.
Here that you're talking about?
Yeah, the second failure to appear.
Got it.
And then the first one that he's talking about in 2007, if you check your records, I also was incarcerated also, so.
Okay, all right, yeah, that one goes back more than 10 years, so. Okay, is there anything else?
Judge, just very briefly, in regards to the use of the driver's abstract, the state can obviously use that as per State v. Mercedes. And in regards to the defendant's ailment, I understand that he's sick, but I don't have the case in front of me. I apologize, but there is case law saying the court cannot necessarily rely just on the ailment in order to release this defendant. Otherwise, Judge, I'll submit.
Okay, all right, thank you. Anything else, Ms. Calzone?
No, Your Honor, thank you.
All right, the general statutory purposes of New Jersey statutes 2A:16215 is to reasonably assure three things. The first is that the defendant will appear in court when required. The second is the safety of persons, or either particular people or the community generally. And the third is that the defendant will not obstruct the criminal justice process. In this case, due to the nature of the charges, there is a rebuttable presumption against detention. That is, that there exists some amount of bail and/or non-monetary conditions of release that will satisfy those three statutory purposes. To rebut the presumption of release, the court must find by clear and convincing evidence that no amount of bail or monetary or non-monetary conditions of release or some combination would reasonably assure the three statutory goals. Evidence is considered clear and convincing when it produces in the mind of the trier of fact a firm belief of conviction as to the truth of the allegations sought to be established, meaning the evidence is so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue. The court may consider, and I have considered, the public safety assessment and the recommendation in it. However, public safety assessments and the recommendations are not binding on the court. They're not dispositive in any way. They're simply a tool for the court to use. Here, the PSA scores Mr. Scott at 3 out of 6 for both the risk of failure to appear and the risk of new criminal activity. There's no new violent criminal activity flag either, and the overall recommendation is to release with conditions, that being monthly reporting. In considering, the court should consider other factors, including the nature and circumstances of the alleged offense, and the weight of the evidence. I do consider the weight of the evidence to be strong here. The affidavit of probable cause describes the conduct that Mr. Scott is alleged to have engaged in. The witnesses are the patrons at the Grasshopper, the staff at the Grasshopper, and the responding police officers. Again, I realize that that's hearsay, but on the assumption that those persons would testify in the general manner that's set forth in the affidavit of probable cause, the weight of the evidence is strong. The nature and the circumstances of the alleged offense, again, it is quite serious. I realize this is not violent in and of itself, and also that the .45 weapon that was allegedly referred to was not actually found. However, people do have the right to be free from that sort of threatening behavior, and that, threats to shoot someone or, to use a .45 would put a reasonable person in fear, and that's something the law prohibits. On the other hand, it does indicate the two things that we've been talking about. One is a substance abuse issue, intoxication in this case, and there may be other drugs as well, but that would be speculation. In addition, it does also indicate some sort of a mental health issue, mental instability. In considering other factors, the history and characteristics of Mr. Scott, he does have the criminal history that has been gone over. It's included to some extent in the PSA. However, as Mr. Talone pointed out, Mr. Scott has the very serious federal charge for a felon in possession of a weapon. That goes back to 2011, apparently the original conduct, and resulted in multiple jail stints for Mr. Scott, in that he was revoked, I guess, 3 times for, I'm not sure if it was parole or his supervised release. It really doesn't matter what that is, but just wound up repeatedly being violated, which is obviously not in his favor. He was eventually terminated not that long ago, in December of 2019. Well, again, I would add that he is apparently a lifelong resident of New Jersey. He does have some ties. His aunt, Loretta Gabriel, and Ms. Calzone has represented that Ms. Gabriel is willing to take in her nephew and let him live there. I don't view his failure to appear record to be all that serious. The one that's in the PSA goes back to 2007. And the driving abstract failures to appear, again, Mr. Scott has spent a lot of time in jail, in and out, and that may be a cause of that. Obviously, there is a danger to the community generally if someone is getting intoxicated and is suffering from mental health issues that cause this kind of conduct. I don't have a particular concern about obstruction. And while I am very concerned about Mr. Scott's failure to abide by the conditions that were imposed on him due to the federal conviction, I still find that the state has not met its burden of establishing by clear and convincing evidence that there are no conditions of release that would reasonably assure the three statutory goals. Again, I really don't have a concern about failure to appear. I do have a concern about the safety of persons in the community. But I think that the following conditions will reasonably assure the safety of the community. Again, I don't have a real concern about obstruction. So the conditions will be, I'm going to increase the PML level to PML level 3. I want Mr. Scott to appear in person every other week and then by telephone every other week, so PML level 3. Mr. Scott, do you understand that?
Yes, sir.
All right, and you're going to be subject to drug and alcohol testing, random drug and alcohol testing. You are to refrain, in other words, you're prohibited from any use of alcohol or non-prescription drugs. Do you understand
All
that?
right. Yes.
And you are required to live with your Aunt Loretta, Ms. Gabriel, at 208 Justin Court in Cedar Knolls. All right, he's not currently working, right? You said he had worked at ShopRite and Panera. Are you currently working,
No,
Mr. Scott?
I'm not currently working due to my injury, but once I get back on my foot, I should be working at the hospital at Morris Memorial.
Doing what?
Probably housekeeping or dietary.
All right. So would you be able, or would you be willing or able to attend AA meetings, Alcoholics Anonymous meetings?
I can attend AA, but I prefer NA because I can identify more.
Okay. You willing to go to NA meetings?
Yes.
All right. Can you get there?
Yeah, I could get there.
All right. And so then I'll add that as a condition that you'll attend NA meetings regularly. Okay?
All right.
All right. Is there anything else?
Judge, if I may, I would ask that he no return to the grasshopper off the green, defendant not to possess any weapons, and I would ask for a mental health evaluation as soon as possible.
All right. Yeah, those are all reasonable under the circumstances. Again, Mr. Scott, you're prohibited from returning to the grasshopper on the green. Frankly, I think most bars are closed, I think. But in any event, we'll specifically include that you cannot return to the grasshopper on the green. Do you understand that, Mr. Scott?
Yes, sir.
And through probation, I'll order a mental health evaluation to be done.
All right.
Okay?
I'm sorry, if we could just let him know of his next pick date.
No possession of weapons. All right. Yes, what is the... all right, so your next court date, Mr. Scott, is before me on April 6th for a pre-indictment conference. Do you understand that?
Yes.
Okay. All right, anything else, counsel?
No, Your Honor.
No, Judge, thank you.
Okay, thank you. All right, were we able to get Mr. Porfido?
Yes, he's on the line, Judge, by phone.
I-
Mr. Porfido,
I
you
am
there?
on the line, Your Honor.
Okay, let me just, give me a minute to organize the paper for Mr. Lopez and just collect the paperwork for Mr. Scott before we begin, okay?
Thank you, Your Honor.
Okay. Okay. All right, let me, Camilla, let me just give you this. Okay, thanks. All right, Mr. Porfido, you're appearing by telephone, correct? Only?
Yes, Your Honor, I'm here.
All right.
Good morning.
Good morning. All right, let me get the, well, is Mr. Lopez there?
He is incarcerated,
Okay.
Your Honor.
Yes, sir.
Yes, no, I just wanted to, I didn't see him on the screen. Now I do. All right, this is State of New Jersey against Antonio M. Lopez. The complaint warrant number is 2020-38-1423 for Morris Plains Borough. We have already conducted the first appearance for all of the defendants today, and we're here for a detention hearing. Let's begin with the appearances of counsel.
Thank you, Your Honor. Gloria responding on behalf of the state.
Good morning, Your Honor. For the record, James Porfido on behalf of Antonio Lopez.
All right. Again, it is March 18th of 2020. The first appearance and the detention hearings are being conducted via video links. There is no one in the courtroom other than myself and court personnel. Ms. Rispoli is appearing via a video link. Mr. Porfido is appearing by telephone, and Mr. Lopez is appearing via a video link from the Morris County Jail. Now, Mr. Porfido, have you had the opportunity to confer in person with Mr. Lopez?
I have not. I've conferred with the family, Your Honor. Mr. Lopez was consulted with the public defender. Apparently, they met with him or they spoke with him, and I have to substitute into the case. There was a representative. I don't know which public defender spoke to him, but I did not.
All right. Do you want the opportunity to do that before the detention hearing?
No, Your Honor, that's not necessary.
Okay.
And Your Honor, if I may.
Yeah.
The state, I did provide discovery to the public defender's office on Monday. Mr. Porfido entered his appearance in the case at about 8:15 this morning. I did speak to him prior to going onto the record. It is my understanding, and he can speak further to that, I did provide him with all of the state's exhibits that were forwarded to the court. So that would be S1 through S3, as well as a Nicole's Law restraining order. I briefly discussed with him moving forward, given the fact that he had not actually reviewed the interviews that were provided in discovery, as well as the forensic interview. And in my discussions with him, my understanding is he still seeks to move forward with the exhibits that the state has provided to him as of this morning.
That is accurate,
Is
Your
that-
Honor, correct.
Oh, okay. All right. Well, again, Mr. Porfido, do you want to review anything with Mr. Lopez beforehand? You
No,
certainly
that's
have
not
the
necessary, Your Honor. That's quite all right. I'm prepared to go forward. I've reviewed chronology of the events. I've talked to family members. I have the complaint, and I'm certainly prepared to go forward. I'm familiar with the circumstances surrounding the arrest and the background of my client, and I think he is anxious to have the matter heard by the court, so I would agree with that as well.
All right. All right. As to probable cause?
Judge, we're not stipulating the probable cause.
Okay.
And my client can offer evidence to the court pursuant to Your Honor's instructions I heard on the last matter with the 5 noted exceptions. So he would be able to provide either a summary or outline to the court of the relevant events and his position regarding maintaining of his innocence.
All right. So in other words, you wish him to testify? Is that?
I do, Judge. I would like him to give a short statement to the court outlining what occurred in this event and what these allegations are as he knows them to be. He was arrested on Friday by the Morris Plains Police Department and a member of the prosecutor's office and brought in for questioning. And to my knowledge, nothing was said of any incriminatory value for the state's purposes. They may view it differently. but I do think that he needs to provide some short information summary to the court regarding this case and his innocence regarding these allegations.
All right. In any event, though, Mr. Porfido, you did receive the limited discovery from the state for the detention hearing?
I've received nothing from the state, but I feel confident with what I have, Judge, from the family and knowing the background of the case and the chronology of events, that I'm prepared to go forward.
Judge, I would just seek to clarify, Mr. Porfido, I did email you an investigative report, the PSA, and the complaint containing the affidavit of probable cause and plea. Did you receive all of those documents and review them this morning?
Let's see. I did not receive an email from you other than the sexual offense restraining order. I've received that.
So that
Let me
email,
just see. I'm looking.
there was a second email containing the state's exhibits.
Let's see. Okay, I have, no, you have a receipt that I sent a letter. Because I had sent a letter to the court on behalf of my client, Judge, submitted by his pastor for purposes of today's hearing.
All right. That, I don't know that I have that either.
I sent a copy to Mr. Montanez as well, and to Ms. Rispoli.
Okay. All right, hold on. We're going to try to locate that.
It's a letter from Mr. Porfido that I emailed.
Okay,
Mr. Montanez
I
is-
do have what, Judge, I'm sorry, I didn't mean to interrupt.
All right, well, let me just, we're trying to find what you might have sent. This is what I'm going to do, though. We're going to just adjourn this briefly. I want you, Mr. Porfido, to make sure you reviewed everything that Ms. Rispoli sent. If you didn't receive it from Ms. Rispoli, the two of you can talk, and I guess it can be re-emailed, but I think at a minimum, I want to make sure you've reviewed what was sent to you. All right?
I have it
And
right
I'll
now,
make-
Judge. I'm ready to go, Judge. I've looked at it. I've already looked at it, and it's really similar to what I've already seen. There's nothing new in the information that's been provided to me. I have the PSA. I'm prepared. It's 3 documents. I have the police report. It's a 1-page report. I've already looked at that. I have the PSA provided on behalf of my client. And I do have the complaint, which was previously forwarded to me by the family.
Okay. And I was just handed the copy, a copy of a letter dated March 17th from, it's signed by Reverend Robert Rogers.
Yes, Your
That's the
Honor,
letter
that's
you're-
correct.
That's the one. All right.
That
So
is correct.
is everyone comfortable going forward now then?
I am, Your Honor.
Judge, the state's position obviously is that Mr. Porfido should at least be reviewing the state's exhibits that were forwarded. I have an email. Obviously, he's now saying he received them, but they went out when I spoke to him at about 9:10 this morning. So it is a 1-page report that Your Honor should have as well that was marked as S3. And he has explained to the state that he previously reviewed the complaint, the affidavit of probable cause, and the clear. So Judge, I would just, before moving forward, like to make clarification that he has had enough time to review and has received everything that the state has sent.
I have, Judge. Yes, I have everything, and I've looked at it already. Now that it took me a quick read, but I have it all, and I'm prepared to go forward.
This is Scott. All right. I don't have, let's see, what I have, I do have, obviously, the complaint warrant. I have the PSA, and that's it. And now, well, now I have the letter from Reverend Rogers. But that's all I have. That's all that's in the physical file. So how were your exhibits sent, Ms. Rispoli?
Judge, I forwarded them yesterday to Mr. Montanez as well as Ms. Fonseca. I can forward them to anyone right now. I do have them up in my email. as well as the Nicole's Law restraining order. So they were sent Tuesday, March 17th at 11:55 a.m.
Okay, I don't have them. We're going to have to get them printed out for me so that I can look at them, okay?
Judge, if for whatever
Okay,
reason
Judge.
Montanez doesn't have them, I can re-forward them to his email if he just wants to let me know.
He's checking right now.
She can just forward it to me, Judge. I print.
What's that?
She can just forward it. I'll print it.
All right. Actually, can you just forward it to Madam Clerk?
Yes, I'm sending them to her right now.
Okay.
Do you have her email address?
I do. It's going to be in 2 emails. The first email will have states exhibits 1 through 3, and the second email will have the Nicole's Law restraining order, Your Honor.
All right, thank you.
They both were just sent.
All right, we did receive it, and Madam Clerk is printing them out now.
Thank you, Judge.
All right, thank you. All right, I've just been handed them. Let me just take a minute to read them. Okay, all right, I've reviewed the exhibits. The first thing is the sex offense restraining order, the Nicole's Law order. And I will sign that. I'm not sure how typically the defendant would sign it here in court. Any suggestions for how to accomplish that aspect of the order?
So, Judge, in my experience, it is similar to a temporary restraining order to some degree, where it may be ordered and then have to be served upon the defendant. So what we would be doing, given the circumstance that we are currently facing with virtual court, I would ask that at the end of the hearing or whenever Your Honor prefers that we go through the Nichols Law restraining order with the defendant over the recording. And then I will speak with my office and the Morris County Correctional Facility in regards to how we go about serving the defendant. We would have him sign it, serve him with a copy, and then we would provide it back to the court for it to be entered.
I don't
Okay.
disagree with that, Your Honor. I think that makes sense.
All right, why don't we, we'll deal with that at the end of the hearing then? So just remind us all, Ms. Rispoli.
Yes, Judge, and we can always have Your Honor note on the restraining order on the second page that it was reviewed via virtual court with Your Honor's signature and that the defendant was present as well.
Right, okay. All right. All right, now, in this case, there is a rebuttable presumption for detention, correct?
So, Your Honor, with the first count of the complaint is first-degree aggravated sexual assault. So there actually is a presumption against release. So the defendant would have to thereby demonstrate to the court and overcome the presumption against release. Right.
So in other words, the framework is that there is a presumption for detention and against release. The defendant, to overcome that, must show by a preponderance of the evidence to overcome, and then that would switch the burden back to the state to show by clear and convincing evidence that there's no amount of bail and or non-monetary conditions of release. Does everyone agree on that legal framework?
Yes, Your Honor.
Yes, Judge.
Okay.
You would have to show that essentially it's met its burden that the defendant should not be released. Yes.
All right. So, again, let me just review the statutory purposes are to reasonably ensure that the defendant will appear in court when required, to protect the safety of any particular person or the community generally, and third, to reasonably ensure that the defendant will not obstruct the criminal justice process. Mr. Lopez, do you understand that?
Yes, Your Honor.
All right, and you do have the right to testify at the detention hearing, and Mr. Porfido has indicated that he does want you to testify. The general rule is that if you testify, your testimony is not admissible against you on the issue of guilt in any other judicial proceeding, including this case. Do you understand that?
Yes, sir.
However, there are 5 exceptions to the general rule where your testimony can be used against you, and I'm going to review them right now. The first is that your testimony will be admissible against you, 1, in proceedings relating to a subsequent failure to appear in court, 2, in proceedings relating to any subsequent offenses committed while on release pending disposition of these charges, 3, in proceedings relating to your subsequent violation of any condition of release, 4, any subsequent perjury proceedings, and 5, to impeach your credibility should you choose to testify in any subsequent proceeding. Do you understand that?
Yes, Your Honor.
All right. And if you are detained, the state must secure an indictment against you no later than 90 days from the date you were first lodged in the jail, and bring the matter to trial no later than 180 days from indictment, not including any tolling period as determined by the court. Do you understand that as well?
Yes, Your Honor.
All right. As to probable cause?
Thank you, Judge. Judge, before you, as indicated on the record, the state offers the following facts by way of proffer as authorized pursuant to State v. Ingram to establish probable cause. Probable cause was found by Municipal Court Judge Michael Carlucci on March 13th of 2020. In addition to that, the state is going to rely on that complaint affidavit of probable cause and the plea for the purposes of probable cause. As indicated, those documents are marked as S1 for the purposes of this hearing. Judge, In reviewing, as Your Honor has the affidavit of probable cause, this case was referred to the Morris County Prosecutor's Office on March 3rd of this year. At that time, a concerned family member had contacted the Division of Child Protection and Permanency, and I'll refer to the victim as XX, as it is in the affidavit, was sexually assaulted by the defendant. The family member had reported to the prosecutor's office, and this is also outlined in S3, Your Honor, Detective May's investigative report that is dated March 13th as well. The caller disclosed to the Division of Child Protection and Permanency that essentially there was a performing of cunnilingus and contact to the XX buttocks at that time. The Division of Child Protection and Permanency contacted the Morris County Prosecutor's Office, and then from there, our investigation pursued. There was a forensic interview that was conducted by Detective May on May 10th with XX. At the time of this alleged incident, XX was approximately 4 years old. And just so that Your Honor has an understanding of the parties at play here, the defendant is married to XX's paternal grandmother. So approximately on the evening of January 17th of 2020, XX was sleeping over at her grandparents' residence. During her forensic interview, she did disclose that her step-grandfather, the defendant, licked her vagina and buttocks using his tongue while they were both sleeping on the couch that was located in the downstairs living room. XX also reported that during the assault, the defendant raised his finger to his mouth and said shh, and told her essentially in effect to keep quiet as to not disturb or wake anybody else up. In addition to that, and Mr. Porfido has alluded to that earlier, a few days after the forensic interview, the defendant was interviewed by law enforcement on March 13th of this year. He essentially corroborated the victim's statement. In effect, he corroborated the fact that he was sleeping downstairs on couches with her. He corroborated the fact that he was taking her back and forth to the bathroom. He corroborated that he was the one that undressed her for the evening for bed. He also corroborated that at one point in time, he, quote, bent her over to check her to see if she was clean, even though she was a child that was potty trained and did not need assistance using the bathroom. But he did deny that any sexual acts occurred on the living room couch. Judge, based upon all of that, based upon the additional information, in addition to that, I should note that there is also fresh complaint testimony that is noted as well. On January 18th of 2020, the victim's mother and father picked her up from the defendant's residence, and upon returning home, XX immediately disclosed to both of her parents what had transpired the evening prior at the grandparents' residence between her and the defendant, and her accounts have remained consistent throughout. So with that, Judge, the state feels that there is sufficient probable cause to move forward, and I submit.
All right. Mr. Porfido.
Judge, I don't mean to denigrate the state's case, but I think in my comments I certainly will be, because this was a classic rush to judgment. These allegations came forward. The mom, I'll identify her for the record, and there's a very complicated family tree here. My client, Antonio Lopez, is married to Penelope Lopez, who has 4 children. Her son, Tishan Smith, is the father of the alleged victim, LS. He is in a relationship with the mother, Kara Pearson. Kara Pearson, the mom, contacted my client's wife, Penelope, the following day, and she recorded the conversation wherein she denied anything had happened and said the words look or lick. She said that she was reported to her by her daughter that grandpa looked at her, and then it became lick. And at some point, she even said, well, she's also said this about her dad, that would be Tishan Smith. That was all recorded on the following day. I have that recording of that interview with the mom. It's interesting that the state,
Judge, I would object.
and I will present that.
As it has not been turned over to the state, and the state has no
I
knowledge.
just received at this moment. The state can object all they want, Judge. We're at a detention hearing. They're going to get everything. And at the end of the day, this case is going to be dismissed because they're going to have no evidence. And I'm confident saying that because I've looked at everything here and there is no evidence. They have a 4-year-old child who has made these allegations up and is inconsistent in her allegations. These allegations were made on January 18th, the following day after an overnight with her grandfather, a man that is gainfully employed, is involved with his church, has no criminal history, no background whatsoever. And I would say the complaint is defective in looking at it because the accounts are not accurate. There may be one count of an aggravated sexual assault due to the act of cunnilingus alleged, which is a first degree, but then the following counts are inconsistent. It's all 4 counts based on one incident occurring on January 17th, and they are not accurate. They should be modified to reflect the proper charges. So with respect to that, that's deficient on its face. But getting back to the dispute as to probable cause, that there is no probable cause that exists in this case. If you look at the state's exhibit that was submitted to Your Honor, it's a police report authored by Detective May from the prosecutor's office. This whole case stems around an anonymous complaint made by a person from Savannah, Georgia. We don't know who this person is. They're not identified. And this is the basis upon which the state embarked upon the investigation. The state says they have a fresh complaint witness regarding allegations made on January 18th, and we're prepared to rebut that, and I will provide the state with that recording. I have no problem doing that, because at the end of the day, there's not going to be a case here. My client did not commit these acts. He maintains his innocence. He was wrongfully imprisoned on this. He was brought into the Morris Plains headquarters on Friday afternoon, the 13th, March 13th. And at the time he was brought into court, his wife contacted an attorney, and my understanding is Brent DeMarco sent a letter to the Morris Plains Police Department and advised them to cease and desist from any interviews of my client. That's another matter for another day, because when the state says he gave an interview that corroborates, that's not true. Their view of corroboration is that he's in the same place at the same time, therefore it must have happened. That's not going to stand up before a jury, but we're not here yet on that point. The point is that there is no evidence in this case. It's a classic he said, she said with a 4-year-old. A 4-year-old. And I can guarantee you when this case gets further along in the process, this 4-year-old will not testify in a case before a jury. I can say that with 100% certainty. Now, as far as my client's concerned and the probable cause aspect, I will be filing a Miranda motion as it pertains to Mr. DeMarco's previous involvement in the case. Any statements that were taken at the Morris Plains Police Headquarters are subject to suppression based upon the fact that he sent the letter and indicated he represented the defendant and therefore he should not have been interviewed. He was whisked away from his home on Friday afternoon, and he's remained in the Morris County Correctional Facility until today. That's why I insisted on having this detention hearing today. I don't want to delay this proceeding any longer. I'm prepared to go forward. The state can give me all the evidence in the world. It's not going to change my viewpoint of this case, and it's not going to make their case any better. Their case will remain a 4-year-old saying that her grandfather did these things and also claiming that she thinks her dad might have done it as well, and also saying it was looked at and then changed to like, and these are all part of a recording made by my client's wife with the mom the following day. I'm pretty
do you want to
clear.
Are you going to play the recording?
I can, Judge. I just was provided it this morning. I've not even listened to it myself, but my client's wife advised me of it, told me of it. I don't know that it needs to be played, but I can assert as an officer of the court what has been represented to me in that recording. I don't hear the state playing that evidence that they just said that my client was interviewed and that was corroborating their story. They didn't play that tape.
All right, you also referred to someone from Georgia. What is that? I'm not sure I understand that reference. I don't see that in the.
Judge, if you look at the states, I don't mean to cut you off. If you look at the states exhibits, the first
Yes.
exhibit that was sent to me by Ms. Rispoli is a police report, and it is authored by Detective Craig May of the prosecutor's office, and I can read it. It's very short.
Judge, it's
It says,
S3, and I can provide any clarification. And I did articulate to the court that the division received a report from a family member. That family member resides in Georgia.
All right, yeah, no, I actually see it says Investigator Casone reported that the division, meaning DCP&P, received a referral the prior day from an anonymous caller from Savannah, Georgia. And then again, it gets into the details of the report. That's what you're referring to?
yes, Your Honor, and that is saying that there was a conversation on March 3rd from a family member in Savannah, Georgia. Mine doesn't even say a family member. That was just reported by Ms. Rispoli on the record, but it does not state a family member. It says that there was an anonymous caller who states the victim had disclosed the suspect licked her vagina and buttocks. The suspect is the husband of the victim's paternal grandmother, Penelope Lopez.
All right. Okay. Is there anything else
Judge,
on probable cause?
Yes, Judge. I would also note that the state did not interview a critical witness who was present the entire time, which is a 12-year-old cousin. And I think if you were to look at a 4-year-old and a 12-year-old, I think a 12-year-old will certainly have the ability to give a recollection of events a little bit better than a 4-year-old. That's just based on my common knowledge. I'm not an expert, but I would say a 12-year-old needs to be interviewed who was present the whole time and would say nothing happened out of the ordinary. Nothing happened on the couch whatsoever, and that is Joshua Smith. And that's why I say the state rushed to judgment. They didn't do a thorough and complete investigation. They just wanted to arrest this man. They took this allegation and they ran with it. And I would say there wasn't even probable cause, Judge. In this circumstance, I would say there didn't even exist probable cause. They didn't do the proper necessary steps to vet this investigation and to get to the truth of the matter. That's what we're interested in doing, right? We want to get to justice and we want to find the truth. We don't just take allegations and run with them and whisk people off the street, arrest them, and put them in the county jail.
Okay. Anything else?
Judge, if I may just clarify a few points that Mr. Porfido placed on the record.
Okay, go ahead.
I would absolutely object to him playing or Your Honor considering this alleged recording. The state has not received it. This is the first I'm hearing of it. And Mr. Porfido has just acknowledged on the record that he himself has not even listened to it. So for him to purport on the record to the court what is said on this recording, he has absolutely no idea, but for the defendant's wife proffering to him what she believes what was stated on that phone call. Secondly, there are absolutely no allegations made during this forensic interview that the victim has made allegations against her father. So I want to make that extremely clear that the forensic interview that was conducted by Detective May with the victim XX, who is a very articulate 4-year-old with absolutely no motive to lie or fabricate these allegations. There was no miscommunication where anatomical diagrams were utilized for her to communicate and describe exactly what had transpired on the evening of January 17th. And Judge, in regards to any other potential interviews that need to be conducted, the state will gladly speak to any additional witnesses. However, there are multiple agencies involved. The children that Mr. Porfido is referring to on the record live in Warren County. We have been working with Warren County Prosecutor's Office and we have to set up interviews with those children, and we will do our due diligence with all of that. And lastly, Mr. Porfido does need to speak with Mr. DeMarco because I was on the phone with him. By the time that Mr. DeMarco was retained, the defendant's statement had concluded. So at the time that we received any communication from Mr. DeMarco, law enforcement ceased all communications with the defendant. So I want to make that very clear that at the time that the defendant was in custody, he clearly indicated and waived his Miranda rights, said that he wanted to clear his name, wanted to speak to law enforcement, but the minute that we did receive communication that there was an attorney involved, communication ceased and the interview was terminated.
I've not spoken to Mr. DeMarco, so I can't give an opinion as to that. I just know that a letter was sent from his office to the Morris Plains Police Department while my client was being interviewed. That's all I can say. I don't know any more than that, Judge. I can say that that presents an obvious Miranda issue.
Okay, thank you. Probable cause exists if at the time of a police action there is a, quote, well-grounded suspicion that a crime has been or is being committed. That's a quotation from State versus Sullivan, 169 NJ 204. In that same case, the Supreme Court instructed judges to make probable cause determinations in a practical, non-technical way, saying, it was actually a quote from Illinois versus Gates, which is a U.S. Supreme Court case, 462 U.S. 213, that with probable cause, we deal with probabilities. These are not technical, they are factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. Here, the affidavit of probable cause and the forensic interview of the alleged victim adequately established probable cause for all of the charges against defendant. There is a description by the child of the conduct complained of against the defendant, who is the child's step-grandfather, of licking both, I guess, her vagina and buttocks. And the child was the subject of a forensic interview. I'm going to assume that occurred at Deirdre's house, Ms. Rispoli?
Yes, Your Honor.
All right. So the Morris County Prosecutor's Office conducted its forensic interview of the child in the in the manner that they are, presumably in the manner that they are trained to do those sorts of interviews, which require, when a young child, such as a 4-year-old, is involved, require certain techniques to be used, and law enforcement concluded from that that the child was telling the truth. I realize Mr. Porfido will raise numerous defenses. There will, it sounds like, be a Miranda motion, which obviously courts deal with all the time. However, that potential defense does not take away from the showing of probable cause. At the probable cause stage, certainly law enforcement is not required to eliminate all potential defenses or to have fully completed its investigation. Again, Mr. Porfido referred to the tape recording that he says he has. He himself has not listened to it, so it's difficult for him to proffer the details of it. He gave me a general description of how it was described to him. But again, I don't have, it doesn't take away from the showing of probable cause that's contained in the affidavit of probable cause, as well as the Detective May's report, which I've also considered. I guess I would also add, again, there are other potential defenses that the child, according to Mr. Porfido, allegedly claimed that her father, not her step-grandfather, but her father did similar things. But again, it doesn't take away from the fact that the child has made the complaint, was forensically interviewed at Deirdre's house, and law enforcement concluded that there was substance to the child's allegations, as well as Ms. Rispoli pointed out, the initial fresh complaint that was made, I guess, the day after the alleged conduct by telling her parents about it. All right, so I've made the probable cause determination, and we will move on then to the detention hearing. I'll hear first from Mr. Porfido, since he has the initial burden.
Your Honor, pursuant to 2A 16215, the court has to review my client's ability to appear before the court, whether he presents a safety to the community at large, and whether or not he will obstruct the criminal justice process. On all counts, Judge, my client will appear in court at any scheduled proceeding. He is not a danger to the community. These outlined allegations are pertaining to an overnight visit with a grandfather. There were overnight visits before. There's been no such allegations ever made. And as I indicated, these allegations are somewhat tainted. And that's an issue that will be pursued before the court. As well, Judge, my client has no criminal record. He has no background whatsoever. I understand there is a presumption in these cases of incarceration. However, I believe that that is overcome by the fact that my client, dissimilar to the last matter that was before the court, has no criminal history, is gainfully employed. He's the manager at Mazda in Wayne. He's been employed there for a significant period of time. And he's a church member. He's an usher at the church, as indicated by Pastor Roberts. I submitted that, or Rogers. I submitted that letter for the court's consideration. This is a man that is a family man. He's been a United States citizen since 2006. He is approximately 39 years of age. He has the love and support of his family behind him. And as I said, when the dust settles, this case will not be proven, and he will not accept a plea. So the state better be prepared to go to trial in this case, because quite frankly, there's not going to be a plea entered. And given these serious allegations that have been made against my client, which are of a first-degree nature involving this incident, we have no alternative but to go forward. Now, as far as the restraints are concerned, there's already been an indication that there was the restraining order presented, the sex offense restraining order, which Your Honor will need to sign because mine is not signed by a judicial officer. And we've already indicated that would be done after the proceeding. But that guarantees there's no contact with this alleged victim. I will present to the court and to the state at the appropriate time the recording made the following day after the incident, which will rebut these allegations. I would say, Judge, that there is no basis upon which to hold this man in custody until this case gets, and the state's even indicated they haven't interviewed all the witnesses. They still need to deal with Warren County and find Joshua, who is the main witness, Joshua Jones, the 12-year-old who was there the whole time, based upon what these allegations are. They've not even interviewed him. So when are they going to get to that, Judge? Does my client have to remain in custody while they continue to do their investigation? My answer to that is no. He should not, and the court can certainly guarantee and release him. And I think that the burden clearly has been shifted over to the state to present to the court that there's clear and convincing evidence as to why he cannot be released. His PSA score is 1. And the recommendation is against release simply because of the nature of the offense.
Let me just review the PSA. The PSA scores Mr. Lopez at a 1-1, meaning the lowest score possible for the risk of failure to appear, as well as for the risk of new criminal activity. Nonetheless, it does have a recommendation of no release, and that's due to the fact that the first-degree charge carries with it the potential for a sentence to life imprisonment. All right, and again, I'll just add further, as you might expect from a 1-1 score, that Mr. Lopez has absolutely no criminal history. There's nothing else on the PSA. But Mr. Porfido, why don't you finish up, and then I'll hear from Ms. Rispoli.
Judge, I would also note that the court may consider the PSA, and you're not bound by those recommendations. So certainly there are alternative measures available to the court to release Mr. Lopez into the community and increase his PML score if that's necessary for him to report. He's certainly able to do that. Even if the court were to put an ankle monitoring device upon him, I don't think it's appropriate in the circumstance, but if the court felt it necessary certainly that could be done. There's no reason why he should continue to be detained while this case gets vetted through the prosecutor's office and we get to a date for trial and he sits there waiting and waiting. I don't think that, quite frankly, this presumptive term as set forth is going to be real at the end of the day when the state concludes its investigation.
All right, thank you, Ms. Rispoli.
Thank you, Judge. Your Honor has indicated on the record in reviewing the PSA, which has been marked as S2, obviously, there is a recommendation that release is not recommended, which is entitled great weight. I do note that pursuant to count 1 of the complaint warrant, as you indicated as well, it does carry the potential for life imprisonment. So pursuant to statute, that alone stands as the rebuttable presumption that the eligible defendant and that this eligible defendant can be detained pending trial. There are several factors that Your Honor may consider. First and foremost, pursuant to 2A:162-20A, the nature and circumstances of the offense charged. So there is now probable cause to believe that the defendant has committed aggravated sexual assault as well as counts of sexual assault against a child victim who at the time of the offense was 4 years old. I indicated previously on my arguments that XX is a very articulate child based upon the family history that the state has in communicating with her mother and father, the fresh complaint witnesses. There was an amicable relationship between the defendant and the family. There seems to be no motive to lie or fabricate. In relation to the charges themselves, again, the defendant, while facing potential life imprisonment, as count 1 would be pursuant to the Jessica Lunsford Act, he is also looking at potentially a state prison offer, likely a state prison offer that would be subject potentially to the No Early Release Act, Megan's Law registration, Avenel, and parole supervision for life. I have gone over the facts with Your Honor in reviewing probable cause in regards to the offense charged. So I do ask Your Honor, again, I won't continue to articulate and go through all of that again, but I would ask you to consider that in relation to your arguments. Mr. Porfido has gone over some of the characteristics of the defendant. Again, it is a 1-1, so the defendant does not have a prior criminal record. There are no indictable convictions on his PSA or criminal history report. The state's knowledge and based upon D1, which was submitted, he has been a member of the Morris County community. However, the state does have some concerns, Judge, in regards to his background. I would point you to S3. It has been learned and information was obtained that due to some financial difficulties, both he and his wife do.
Judge, I'm going to object to this because it's not relevant for the court's consideration. I really would not. I think that was not, quite frankly, relevant to the considerations the court has to take into account. Whether they've moved from time to time, it's not appropriate for the state to say that they didn't pay their bills or something to that effect, which is what the report says.
All right, I'm going to overrule the objection. I can consider the history and characteristics of the defendant, but how much weight I'll give to it, let me hear what it is first.
Judge, thank you. Essentially, what the state is asking you to consider in regards to weight with his history and characteristics is an unstable housing situation. There is a history and a repeated pattern that is outlined in the police report that was turned over that the family moves every couple of months to upwards of a year due to financial circumstances, that they do not have stable housing. So that is of concern to the state. Again, he is married to the victim's paternal grandmother. Another concern to the state is that he has access to several grandchildren. Mr. Porfido has mentioned one of them. There are 3 other grandchildren, all under the age, I believe, of 14 years old. And Judge, in relation to that, Mr. Porfido makes arguments regarding that his client shouldn't be held pending the state's investigation. There are more than sufficient proofs at this point in time to detain the defendant. Us continuing our investigation currently in the times that we are with complying with COVID-19 and the coronavirus, there is limited exposure to children right now. So the state is doing its best, given the present circumstances, to continue its investigation. keeping in mind the health and safety of not only law enforcement, but also the other children and the families of those children that need to be interviewed. So
All
Judge,
right, I need to just step off the bench for 2 minutes, so if everyone could
Judge,
just.
Judge, may I
stay-
respond just briefly to a
Yes,
couple of the comments
yes.
that were made, if I may?
Yes,
Before Your Honor steps
yes,
off the bench. The reason, the
just hold
COVID-19 is
the
not a
thought.
reason.
Jim, we're not
Sure.
on the, Jim, we're not
Okay.
on the,
Thought. I'll allow you to respond in just 2 minutes, okay?
Thank you.
All right, we're back on the record. Let me have Ms. Rispoli finish her remarks, and then I'll hear from you again, Mr. Porfido.
Thank you.
Judge, so moving on with the factors that you can consider under subsection D, the nature and seriousness of the danger to any other person or the community posed by the eligible defendant's release. Obviously, this is one of the most egregious crimes that you can commit in the state of New Jersey and that you can be charged with. It's a quite serious offense. He does pose a danger to XX, as well as any other children that he may come into contact with if he were to be released. So the state has serious concerns in regards based upon the allegations presented. And I know Mr. Porfido has said that this is the first time the family is learning this, and that he may not have done this with other grandchildren, but as the court is well aware, as so is the state, is that these cases, sometimes it is one grandchild, sometimes it's not all of the grandchildren. So I don't believe that that's a valid argument to make or to remove from the seriousness of this particular crime, that it was just this particular grandchild and it hadn't happened before with any of the other grandchildren. In regards to subsection C, Your Honor, the nature and seriousness of the risk of obstructing or attempting to obstruct. Obviously, while I understand Your Honor can't consider this alone, the seriousness of the offense and the potential sentence upon conviction. Not only are these offenses that are subject to no early release, but count one is subject to life imprisonment. So the risk of non-appearance or potential flight in relation to these offenses. But I strongly argue to the court the defendant's own actions and behaviors in committing the crimes. The fact that during the assault, he signaled to the victim to keep quiet is of large concern. And that goes to not only risk to the community that he would pose to the victim and others, but also risk of obstructing or attempting to obstruct. This is obviously, as Mr. Porfido has said, this has divided a family. The state has serious concerns that there may be some type of tampering with this family and this particular victim. So I do have some current concerns in relation to that. And lastly, Judge, subsection F, the release recommendations of pretrial services is release not recommended. So Judge, with pretrial services making a recommendation that he not be released, that being entitled great weight, in addition to the statutory presumption of detention, I don't believe that the arguments placed on the record by Mr. Porfido have overcome the presumption of detention. I believe that there is clear and convincing evidence as proffered by the state and the exhibits presented to the court that there is no amount of monetary bail, non-monetary conditions, or combination thereof that would reasonably assure the protection of the safety of others. Judge, I would ask that any exhibits based upon the fact that there is a minor victim involved, a sexual assault here, be sealed. And we can go over this, but again, the state is seeking a Nicole Saul restraining order. And Judge, I would also ask that if Your Honor is not going to detain the defendant, that any conditions moving forward involve supervised contact with any children.
All right, thank you. Now, I'll hear from Mr. Porfido, and then again, Mr. Porfido, you indicated that you do want your client to testify, so.
Yes, Your Honor.
You can do that in any way.
Why don't I allow him to address the court at this time, Your Honor, then I'll close with some comments to the court in response to the state.
All right, that's fine. All right, Mr. Lopez.
Yes, Your Honor.
Again, do you understand that you're still under oath?
Yes, Your Honor.
Okay. All right, what is it that you'd like to say?
I would just like to say that I'm an innocent man. I'm not guilty of these charges. And I love my grandchildren. I would never do such thing. I just want to clear my name, and I think that's all I want to say to the court. Is that okay,
All right,
Mr.
Mr. Porfido?
Yes, Your Honor. I want to address Ms. Rispoli's comments about
Well,
other
is there
victims.
anything else? I think your client, do you want to confer with him?
No, Judge, it's okay. I think that what he said is what I would want him to say, Judge, is he's maintaining his innocence. He did not do this. And that is exactly what I expected him to say. And Judge, I think that gets me to the point that I want to make regarding Ms. Rispoli's comments about other victims and him having access to other children. It's completely unsupported whatsoever. The state can't just throw out any speculation and innuendo and try to prejudice the court against my client. That's just not the case here. They have one isolated incident that they're alleging happened on January 17th that wasn't reported until March 3rd, and my client was taken into custody on March 13th and has been sitting in the county jail since that date. They can't change that. You can't change what's happened in their investigation. Why they haven't interviewed other witnesses? Well, they can blame it on the COVID-19 all they want, but that plays both ways. My client should not sit in the Morris County Jail waiting for the state to do their investigation and have access to these children. The presumption has been overcome, Judge. He has no criminal record. Regardless of what these allegations are, they're going to be disproven and they're going to be shown to be false. Whether we take that on or the state figures it out on their own when they do their investigation, that's completely up to them. But we're completely in the position here, Judge, to maintain innocence. He has said nothing to incriminate himself. And, Judge, this is a serious case. The state's already throwing out Jessica Lunsford's statute, which means if they recommend a sentence of 20 years, that means 20 years without parole. If they throw 15 years out, 15 years without parole. There is no plea offer that's going to be accepted in this case. So the state better start preparing for trial. That's what I'm saying, Judge. There's no plea. He's maintained his innocence. It's black and white here. Now, the state says there's no axe to grind here. When this victim comes before the court, that's not true. That's just not true because the mother, Kara Pearson, has a problem with Tishawn Smith, the father of the child, and Penelope Lopez, the grandmother, because they are allowing their son to engage in another relationship with a woman by the name of Daniel Dumas, who he has a child with as well. So Mr. Smith, the father of the alleged victim, is carrying on a relationship with two women. I don't know how he does it. I think he's crazy, but he is. But that is a problem that is causing a lot of animus. And quite frankly, I believe that the mother's credibility is going to be subject to question. And certainly when I give the state that interview, that phone conference held the following day, it's going to raise significant questions about these allegations. And again, Judge, we're looking at a 4-year-old victim. The state can say all they want. She's credible. She's believable. She's very mature for her age. She's 4 years old. They can't change that either. That's what this case is based on. A 4-year-old saying that grandpa looked at her, licked her, and it might have been dad as well, as presented by the mom. This matter, the court has to have a firm belief in the truth of these allegations And Your Honor cannot believe that hearing all these things. You cannot be firmly believing that the state is going to prove this case based upon the information that you have before you right now. So I believe he is subject to release. I believe the state has not overcome by clear and convincing evidence the presumption that they have, and that Mr. Lopez should be released, and the court can certainly ensure his safety. He is not a danger to the community. There's already a restraining order, sexual assault restraining order in place. He's not having contact with his alleged victim. He would be crazy to even think about that. He's no danger to the community. He has a job. He's gainfully employed. He's a member of his church. His pastor speaking on his behalf, and he certainly is not going to obstruct the criminal justice process, Judge. So there's certainly nothing here, nothing that would not allow this man to be released at this time while this case is investigated, which the state has acknowledged they have not done yet. They're saying it's not going to change anything. Well, it is. If they interview this young boy and he says, hey, it didn't happen, I think they've got to give that to me, and I think they got to turn that over. They can't hide that. That's called exculpatory evidence. So he should not sit in the county jail until they do that.
All right, well, Mr. Spoli, you're aware of your Brady and Giglio obligations, correct?
Judge, I am. And the child that Mr. Porfido is speaking of has communicated to DCPMP that he was asleep. So we are intending on speaking with him, but at this point, we have no information that he actually witnessed anything that went on during the late hours. So we will be following up, and we are aware, I'm fully aware of my obligations. And if any other discovery that is obtained will be timely turned over to Mr. Porfido. And Judge, lastly, as far as Ms. Pearson having a vendetta, the victim reported disclosed to her father as well. So if Mr. Porfido wants to argue that Ms. Pearson has a vendetta because the victim's father is engaged in another relationship, quite frankly, that doesn't make sense because the father is a fresh complaint witness as well. And his daughter disclosed to him what had transpired. So I'm not quite sure that that argument has any validity.
All right, is there anything else from anybody?
Judge, I would submit at this time, I think I presented all of the arguments. I do believe, quite frankly, that my client is appropriate for release, and the court can certainly set conditions to have him released into the community while this case is pending and the state does their due diligence and their investigation, which I think they need to do.
All right, thank you. All right, the general statutory purpose of New Jersey statutes 2A, 16215 is to reasonably assure three things. The first is that the defendant will appear in court when required. The second is the safety of particular people or the community generally. And the third is that the defendant will not obstruct the criminal justice process. This is one of the few categories of cases where there is a rebuttable presumption for detention due to the potential life sentence. In most cases, there is a rebuttable presumption against detention. To overcome that rebuttable presumption for detention, in this case, the defense is required to show by a preponderance of the evidence, not by the clear and convincing evidence standard, but by a preponderance of evidence standard that the three statutory goals can be met with either some amount of bail or conditions of non-monetary conditions of release. If the defense is able to do that, then the burden shifts back to the state to show by clear and convincing evidence that there is, in fact, no amount of monetary bail, non-monetary conditions of release, or some combination of those two things that would reasonably assure the three statutory goals. Again, I just want to, so the record is clear, I just want to state what the clear and convincing evidence standard means. Evidence is clear and convincing when it produces in the mind of the trier of fact a firm belief of conviction as to the truth of the allegation sought to be established, meaning the evidence is so clear, direct, weighty, and convincing as to enable a fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue. As I guess both sides have pointed out, The court can and should consider the PSA, the Public Safety Assessment, and its recommendation. However, I want to stress that a recommendation in a PSA is in no way binding on the court. It is simply a tool for the court to use in reaching a wise decision. I have certainly, in other cases, released defendants who had no release recommended, and conversely, I have detained defendants who had release recommendations, but I always consider the PSA and the recommendation in it. Here, as I said before, the PSA scores Mr. Lopez as low as you can go on risk of failure to appear and the risk of new criminal activity. He is a 1-1. There's no new violent criminal activity flag. However, there is no release recommended due to the potential for a life imprisonment sentence for that first-degree charge. Looking at the nature and the circumstances of the alleged offense and the weight of the evidence together, those are two factors the court should consider. The nature and circumstance of the alleged offense, the allegations are of heinous conduct of a step-grandfather sexually assaulting a 4-year-old step-granddaughter. Again, that is obviously, the allegations are of a depraved and heinous conduct. Looking at the weight of the evidence, the case really, to a large degree, will rest on the credibility of the 4-year-old, the victim. Mr. Porfido has pointed out various ways in which he will challenge the state's case, including attacking the credibility of the mother of the alleged victim, and the fact that as of this moment, the other child in the room, the 12-year-old Joshua, has not yet been interviewed. However, I do view the weight of the evidence as strong. The child was, or a forensic interview, I should say, of the child was conducted at Deirdre's house by law enforcement trained in such child interviews. And as I said earlier in making my probable cause determinations, law enforcement concluded based on that interview that the child victim was telling the truth. Ms. Rispoli has also pointed out that there is fresh complaint evidence, not of a complaint just to the mother, but also the father in question. I do realize in these family settings that the credibility of both parents will be at issue. However, nonetheless, I do conclude that the weight of the evidence is strong. Looking at Mr. Lopez's history and characteristics, I accept what Mr. Porfido said, that he has been gainfully employed at, I think you said Mazda, was that?
Mazda of Wayne, Your Honor.
Mazda of Wayne, right, for some time. I have received and read the letter from Reverend Rogers, writing a very supportive letter of Tony Lopez, as he calls him. And this is, this is a long-term relationship. Reverend Rogers says he served as Tony's pastor for more than 10 years, active member of the congregation, and it goes on to give a very favorable description of Mr. Lopez. And again, Mr. Lopez does have both employment and family in the community, so those are all factors in his favor. a complete absence of any court history of any kind. Nope, just nothing, absolutely nothing in the way of, not even a disorderly persons offense or anything like that in his record. So that is certainly in his favor. And obviously, since he has no criminal record, he's not on probation, parole, or anything else, PTI, conditional discharge, anything like that. Another factor to be weighed and considered is the nature and seriousness of the danger to any other person or the community. Again, given the nature of the allegations, there is clearly a danger to other children, not just this child, but obviously this child, the alleged victim, and other children, anyone, and again, I'm not making a determination on the merits here, but anyone who could do such a thing is at risk of doing it to other children, so that is significant. In terms of the risk of obstruction in general, because of the potential for such significant sentences, which again, we have the potential for life. We have, for any first-degree charge, it could be up to 20 years as well. And again, these are subject to the No Early Release Act, so these are extremely long, significant potential sentences here, and that does give rise and increase the risk of flight. And again, really based, frankly, on that is the reason we have the no release recommended here from the public safety assessment. In weighing and balancing all of those factors, I do find that the defense has failed to overcome the presumption. The defense has not established by a preponderance of the evidence its burden that there are non-monetary conditions of release that would assure the 3 statutory goals. I do find, again, that the nature and the circumstance of the alleged offense are, and again, these are allegations, but it is depraved and heinous conduct on a 4-year-old, licking the vagina and buttocks of a 4-year-old, counseling or telling the child to, shush, to be quiet, to not tell anyone about it. There is some degree of corroboration, I should add. Again, the defendant did not admit to that conduct, but he did admit, according to the affidavit of probable cause, sleeping with the victim downstairs in the living room on the evening in question, and as well as, changing her clothing and assisting her in the use of the bathroom. Again, I want to stress that the affidavit of probable cause does contain that Mr. Lopez's denial of any sexual acts occurring. I really don't give much weight to the point. It is in the Detective May's report about changing residences and moving due to the default on the rent payments. I really don't give weight to that. I give most weight to the nature and circumstances of the offense and what I perceive as the strong weight of the evidence against it, and again, coupled with the potential for very lengthy jail sentences, including up to life imprisonment, that increases the risk of flight or other forms of obstruction. And there is a danger to the victim and to children generally. And even assuming arguendo that the defense had met its burden of establishing or of meeting the preponderance of the evidence threshold, I would nonetheless find that the state, by clear and convincing evidence, has shown there is no amount of monetary bail and or non-monetary conditions of release that would reasonably assure the three statutory purposes, really for the same reasons that I just went over. I am clearly convinced of those findings. So for those reasons, Mr. Lopez will be detained pre-trial. We'll get to the Nichols Law restraining order in a minute, but I do want to first clarify, and Mr. Porfido will go over this with you, Mr. Lopez. You do have the right to an expedited appeal, and that's to be filed electronically. Mr. Porfido is familiar with that. That has to be done within 7 days, and for the appeal, you have to get the transcript as well on an expedited basis. Mr. Porfido, you'll be meeting with Mr. Lopez to go over that?
I will, Judge. I'm away from the office today, but I will be meeting with him upon my return, and I'll be back in the office by Monday, so I'll be meeting with him Monday at the jail.
All right. I will also point out, and I know both counsel are aware of it, Mr. Lopez may not be, to the extent there is a significant development in the state's investigation that is disclosed as either, Brady information, exculpatory information, or Giglio information as to a witness, that may be, I'm not, I'd have to make a decision on it, but it might be the basis for a motion to reopen detention under subsection F of the statute. And obviously both counsel are aware of that. Correct?
Yes.
Yes, I was actually
Okay.
going to ask the court if I may file a reconsideration motion upon receipt of any information which disproves these allegations.
Well, I would say, since it's probably new information, rather than reconsideration of what I'm basing my decision on today, you can file whatever motion you want, Mr. Porfido, but I think it's best filed as a motion to reopen under subsection F based on the new information.
Understood.
Okay. All right. I think the only other thing then to go over is the Nichols Law restraining order. Again, if you are released, Mr. Lopez, you will be barred from going to the residence of the victim, to the school of the victim, or having any, kind of contact, oral, written, electronic, any other form of contact with the alleged victim. So no form of contact. And that includes any form of social media. And also what you cannot do directly, you cannot have someone else do for you indirectly. And that obviously includes while you're in jail as well. All right, do you understand that?
Yes,
Mr.
Your Honor.
Lopez, do you understand that?
Yes, Your Honor.
All right, and at some point, Mr. Lopez, I'm going to sign the order today. I believe a sheriff's officer will bring it to you in the jail and ask you to sign it as well. Okay?
Okay, Your Honor.
All right, is there anything else on the restraining order, Ms. Rispoli?
Judge, if you could just, below the line where it says defendant's signature, if Your Honor could just write that the defendant acknowledged receipt or verbal understanding on the record on today's date. And I don't believe that the sheriff's or the sheriff's office or jail would be serving it. I'm going to be looking into that with my office. I believe we might be able to send it with his paperwork down to the jail. Maybe that's a possibility, and they could have him sign it when they do that, and then give it back to the court to scan and send it back to the state. But I will be...
Who does that, though?
So generally, whenever a defendant is brought over to court, they would get a copy of the order or the Nichols Law restraining order. So the pretrial order as well as the Nichols Law. I have to check in with the sheriff's department to see how any documentation is getting back to the jail at this point in time. So I will follow up with all of that and be in touch with Mr. Montanez and Mr. Porfido, and I can advise how we're going to get the document signed and a copy to him.
All right. In any event, I've signed I've signed the order and I've written below the now blank defendant's acknowledgement that it's been reviewed with defendant on the record today. Okay?
Thank you, Judge. Can someone
Yep.
scan and email me a copy of that?
Yes, what I'll do is I'll have Madam Clerk email it to both you, Ms. Rispoli, and to you, Mr. Porfido.
Thank you,
Thank you,
Judge.
Judge. Did Your Honor set a date for the next hearing in this matter?
Let me just check. It should be on my schedule. If I can find that before. All right, the next appearance is the first pre-indictment conference before Judge Taylor on April 13th.
Okay, thank you, Your Honor.
Thank you, Judge.
All right, is there anything else?
No.
All right,
No, Your
thank you
Honor.
both.
Thank you.
Thank you all. All right, bye-bye.
Have a good day. Be well. Bye-bye.
All right, just sit tight for a second, all right?
Okay. All right, just counsel, which one, I have to prepare the order in the prior case. I'll need a couple minutes, but which case would you like to handle next? Or from the
Judge.
sheriff's office? Do you have a preference on the order?
Your Honor, we don't have a preference. Whoever you want to have next is fine with us.
Okay. Any preference from counsel?
Judge, I'm ready on Walker.
Walker, okay. All right, just give me a few minutes to prepare the order from the prior case.
And Judge, we're ready on Steffner as well.
Okay. Beg pardon? He's gonna do what? Well, he wanted to do one to see if we can do a simultaneous.
I'm sorry, Your Honor. I don't know if it's too late, but is there any possibility you could take Steffner next? It would help us out a little bit.
Sure, yes.
All right.
I do need about maybe 5 minutes to prepare the order in the prior case.
That's fine. We got Steffner up here now, so we're just going to hang tight for a little
Okay.
bit. And then when you're ready, we'll send him up.
All right, that's fine. I just give you the Lopez materials? Okay. That's another one. Thanks. All right, are we ready with Mr. Steffner?
I am Judge, and I think AP Talone just texted me. There he is. He's right there.
Yes, Judge, we are ready.
All right. All right. Mr. Steffner, are you there?
Yes, Your Honor.
Okay. All right. All right, this is State of New Jersey against Daniel R. Steffner. The complaint warrant number is 2020-2017. I'm sorry. The complaint warrant number is 2020-271438. And earlier today, we conducted the first appearance. We are now proceeding to the detention hearing. Let's have the appearances of counsel, please.
Good afternoon, Judge. Justin Talone on behalf of the state.
Good afternoon, Judge. Brittany Calzone on behalf of Mr. Steffner, appearing via video court.
All right. All right, Ms. Calzone, did you receive the limited discovery for the detention hearing?
I did, Your Honor.
All right. Mr. Steffner, if the court makes a finding of probable cause, you will enjoy a rebuttable presumption against being detained prior to trial. To overcome that and to detain you, the state must prove by clear and convincing evidence that there is no amount of bail and/or non-monetary conditions of release that will reasonably assure three things. The first is that you will appear in court when required. The second is the protection of the safety of any particular people or the community generally. And the third is that you will not obstruct the criminal justice process. Do you understand that's the purpose of a detention hearing?
Yes, Your Honor.
All right. And you do have the right to testify at the detention hearing and challenge the whatever information the state is presenting. Do you understand that?
Yes, Your Honor.
The general rule is that your testimony at a detention hearing is not admissible against you on the issue of guilt in any other proceedings. There are 5 exceptions to that rule where your testimony can be used against you. Do you understand that?
Yes, Your Honor.
I'm going to just go through the 5 exceptions. Your testimony is admissible against you in proceedings relating to your subsequent failure to appear in court. Number 2, in proceedings relating to any subsequent offenses committed while on release, pending disposition of these charges. The third is in any proceedings relating to your subsequent violation of the conditions of release. The fourth is in any subsequent perjury proceedings. And the fifth is to impeach your credibility if you testify in any subsequent proceeding. All right, so there are circumstances where your testimony can be used against you. Do you understand that?
Yes, Your Honor.
All right. And Ms. Calzone is allowed to, under the court rules, to simply tell me what you would have to say. So for now, we'll proceed in that fashion. She'll make what's called an attorney proffer. And then after she does that, I'll ask you if you want to testify, okay?
Okay.
All right. If you are detained prior to trial, the state must secure an indictment from the grand jury no later than 90 days after you were first lodged in the jail, and bring the matter to trial no later than 180 days after the grand jury returns the indictment, although that 180 days can be extended. Do you understand that?
Yes.
Okay. All right. As to probable cause?
Your Honor, similarly to Mr. Scott, I have not spoken with Mr. Steffner in a while, so I would ask that the state establish probable cause.
Okay, all right. Mr. Talone.
Thank you, Judge. Judge, we did submit via email. I believe you have these 3 items I'd like to submit into evidence. Actually, just 2 of them, Judge. S1, which is a complaint affidavit and clear, charging this defendant with a 3rd-degree terroristic threat. S4 is the Washington Township investigation report as well. So I'd be relying on those 2 for probable cause. As it goes towards probable cause, Judge, this event occurred on March 6, 2020 in Washington Township. About 10:30 in the morning, Washington Township Police responded to Radiology Associates of Hackettstown on a report of a threatening phone call. Actually, it was actually multiple calls, Judge. I'm going to use initials, Judge, just to make it a little bit easier. RS is the billing manager and advised that several calls were taken from the billing department, and there was threatening phone calls, and it later was identified as this defendant. Defendant was apparently irate because of a billing issue, and that was sent to collections through there. Judge, I'll go through this. There's several people he made threatening statements to. One of them was PK, where defendant was yelling and demanding money, demanding a number for collections, and he said, quote, that he would come with a can of gas and burn down the building, end quote. He then repeated that to another individual, EW. He said the same words, essentially the same statements, Judge, twice to that person, and then he said it to another person, CC. So that is 4 times he made the statements that he would be coming down there and burning the building down with a can of gas. At this point, the police were contacted. Defendant continued to call. It appears that another individual and me told him that the police were contacted, and he made a statement that was really the Hackettstown police flying by at 70 miles per hour. Hope they or you hit a tree, end quote, Judge. He then spoke to another person on the phone and said, quote, I'll slit your throat, end quote. The police officer, when they arrived, he was on the phone. Defendant called again at this point. Police answered the phone and actually stated to him that he was a police officer, and defendant stated, quote, you will get yours, end quote. Defendant was located at a motel in Warren County when he was arrested, and while being processed, he made some spontaneous inculpatory statements saying that he did not mean to do it and he would not have acted on it, and that he was sorry and was upset that they took his money. Judge, I would also note that the collection agent, this number that the defendant used was the same phone number. It was the same bill and ID that they were talking about for him. So clearly was this defendant on the phone. So Judge, with that, the state will submit.
Okay, Ms. Calzone.
We submit as probable cause, Judge.
Okay. All right. I have reviewed the affidavit of probable cause in the complaint warrant, and also State's Exhibit S4, which is the Washington Township Police Report. The probable cause standard has been described as a low burden. It is a well-grounded suspicion that an offense has been committed. That's State versus Sullivan, 169 NJ 204, 2001 case. And again, the probable cause determinations are to be made in a very practical, non-technical manner. Here, there's no question but that there is probable cause for the third-degree charge of terroristic threats. The conduct described is the defendant apparently being upset over an $86 bill from Radiology Associates and threatening to do such things as bringing a can of gasoline and burning down the building of the folks trying to collect, as well as trying to slit their throats. So no question in my mind, but that the probable cause standard has been met. It's based on the police investigation that's detailed in more detail, certainly in the police report, and based on the interviews of the alleged victims. And it does indicate, again, and there could be a Miranda issue, I suppose, but it does say that when Mr. Steffner was in custody, he spontaneously said that he didn't mean to do it, which is an admission, and that he never would have acted on it, and that he was sorry for causing the problems and really didn't mean it, just upset about the money issue, I guess. So there is that corroboration as well. All right, so we'll move on then to the detention hearing. I'll hear first from you, Mr. Talone.
Thank you, Judge. Judge, I would also like to submit into evidence S2, which is the defendant's PSA. It's a 3/3 PM1 recommendation. S3 was not submitted, Judge. That was a CCH, which I'll just profit from now, from this point on. Some of that, most of it, though, Judge, I do believe is reflected in the PSA. Judge, clearly the state has concerns with this defendant's danger to the community and defendant's ability to obstruct. Looking at the nature and circumstances, this is not just a one passing statement that was made to somebody. He literally repeated this multiple times to multiple different people as he continued to call and make this continued threat. Again, I do not see this as a passing argument or a passing state that he was in. And even when confronted with a police officer, he even says, "You will get yours," at that point. And even before that, he even told another person individually that he would slit that person's throat. So the state does have those concerns as well. Looking at his history and characteristics, this defendant has 8 arrests. He has 3 prior DPs for a simple assault in 2006, a criminal mischief, and a simple assault in 2011. So some of those all are assaultive in nature. The 2011 criminal mischief, he also pled guilty to a PDP harassment, which is on his CCH, Judge. And he was originally charged with a terroristic threat, but that was ultimately dismissed. He also has a PDP disorderly conduct adjudication from 2012 and another PDP harassment from 2013, which is on his CCH, Judge. And I don't think that is actually on his PSA. Judge,
sorry, when were the PDPs?
Judge, it was 2012. A disorderly conduct and a PDP harassment in 2013. Those are on his CCH. Judge, I will proffer that this defendant does appear to have some mental health history. There was, and I'll proffer this, and I turn this over to defense counsel, that he, Hackettstown PD stated that he does have some mental health issues. And even speaking with counsel, he is in a type of mental health program right now, which is concerning for the state as this defendant committed these offenses while he's still receiving mental health treatment. We do have serious concerns about the danger to the community. Without an updated mental health evaluation, it would be, I think, a risk to actually have this defendant out there. With that, Judge, again, I think this defendant should be detained, and I would ask that you detain him at this time.
All right, thank you. Ms. Calzone?
Thank you, Judge. First, discussing the nature and circumstances of this offense. Understanding that this does appear to be a completely disproportionate response to the circumstances that were laid out in the police report. However, I think I can provide some context that may, well, not excusing the behavior, may explain it. Mr. Steffner was in the process of getting a new apartment. He has been trying to get this apartment for some time. He was in the final stages of getting this apartment. And unfortunately, when this radiology center sent the $86 bill to collections, Mr. Steffner, his credit score was placed in a very poor position as a result of that bill having been sent to collections. And again, that $86 bill, as reflected in the police report, was actually paid. So this anger was not out of an inability to pay or them taking his money. He acknowledged he owed the money, but the frustration was born out of the fact that the bill had been sent to collections in his eyes unnecessarily. So again, Your Honor, just to place some context, but again, acknowledging this is a disproportionate response if we are to take the state's allegations, which Mr. Steffner does acknowledge that this was a disproportionate response. And in fact, Your Honor, when the police contacted Mr. Steffner, he informed them of where he was and said, I'm going to stay here. Please come get me. So the police reached out to Mr. Steffner after he had been calling this location. But instead of running or trying to evade police, when the police returned his call, he informed them of where he was. He even gave them the room number of the motel he was in, and he remained there until they came to get him. And in fact, the only reason he didn't voluntarily surrender himself, as he told the police, was that he didn't have a means to get there. He didn't have a car to get to the police station. So he stayed where he was, said, this is exactly where I am, come get me, and did in fact stay there until the police did arrive. So I would submit that that's opposite of a flight risk in this case, or someone trying to evade prosecution. As Your Honor noted, there may be a Miranda issue with the statements made to officers, but even if we are to look at those statements as admissible, they are technically admissions of guilt. However, they also display immediate remorse and understanding that this was a disproportionate response. Mr. Steffner told the police that he never would have acted on these statements that he made impulsively and out of anger. And I think that the fact that he would not have acted on them is corroborated by the fact that he had no means to act on them. When they did go get Mr. Steffner, he had no weapons of any kind with him. And in fact, he doesn't even know these women who work at this facility. This was a stranger to stranger incident, aberration here.
Right, but if I may, I mean, the disproportionate nature, which is putting it mildly, of the response to somebody trying to collect an $86 bill, it does indicate that that Mr. Steffner might be suffering from some mental health issues.
Yes.
In addition, the police report, and you mentioned that he was staying at the Broadway Motel. I guess that's in Warren County. And so he doesn't seem to have a stable place to live, nor a car.
With regards to the car, Your Honor, I don't believe he does not have a car. However, he does have a stable place to live. That motel is paid for by social services. It's actually subsidized housing, essentially. He has been living in that location. Mr. Steffner, how long have you been at that location?
Just a few months, but I also have one other thing to say about the money.
Okay, well, we can talk, but we're just going to address the judge's concerns first about your house.
Okay.
Yeah,
So,
I'll
I just
ask you
started paying. Sorry, Your Honor.
I'll ask you in a few minutes, okay? Just hold the thought, okay?
Yes, Your Honor.
Thank you, Daniel.
All right, go ahead, Ms. Calzone.
Thank you, Judge. Is Your Honor in receipt of the letter that I sent over from Bridgeway Rehabilitation this morning and marked as D1?
Yes, I have the letter from Jeffrey Tholin or Tholin.
Yeah, Tholin, Jeffrey Tholin. So as Your Honor correctly noted, there are mental health issues here. However, Mr. Steffner is under the intensive supervision of licensed clinical social worker Jeffrey Tholin and the Bridgeway Rehabilitation Services. Unlike other programs like Mental Health Association, which we've been dealing with in some other cases lately, this program is much more hands-on and is in fact designed for people who have been treated inpatient for mental health issues. You actually can't be in the program unless you've been treated inpatient for mental health issues. They do see him 3 to 4 times a week. He's assessed quarterly by their packed for psychiatrist. He's also got ample access to, those psychiatrists who can provide medication, but also master's level counseling staff. speaking with Mr. Tholen, he indicated that they work very closely with Mr. Stefner all the time, right down to the fact that they go grocery shopping with him. This program is almost what I would analogize to a program for adults that we see sometimes with developmental disabilities, where their every daily tasks, they receive help with the most basic things in recognition of the mental health issues that they may face. Mr. Tholen did indicate that in light of this most recent incident, Mr. Stefner is going to be referred to their psychiatrist for an evaluation. He has been on medication in the past. He's not currently on it. He's not currently prescribed any. So it's not like he's prescribed something that he's voluntarily not taking. Hold on one second, Mr. Stefner. I see your hand, but hold on one second. And so Mr. Tholen has said that he is going to refer him to the psychiatrist.
I didn't see.
Hello?
Hold on there, Round surveying the video.
We lost.
Yeah, Tony, I don't know where he is though. Let me just see if I can. Hi guys, can you hear me?
Yeah.
Yes.
Okay, so on our screen where we were watching the court, it like cut off. So I don't know what's happening, but I saw Brittany, you said some things that at the end we didn't catch. So I'm gonna try to see how we can put it back on the screen, okay?
Okay.
So just, hold on for a second if you can bear with us.
Okay.
Thank you.
You.